All right, everyone. Happy Thursday. Welcome to the 187th District Court. Let's keep it as a Thursday and let's not try to turn it into a Monday. And everyone should be happy because we are one day away from Friday. At least that is the rumor. These are the rules of the 187th District Court. You are in a courtroom. Anything that you could not do if you were physically in the courtroom, you can't do on this Zoom screen. If you behave inappropriately on the Zoom screen and you're at your house or at your work, your Zoom privileges will be revoked. You will be required to appear in person in the 187th District Court, which is located at 300 De La Rosa, downtown on the 4th floor. And if you do that, your Thursday is going to become Monday because you're going to have to get an Uber or a Lyft or take the Via bus. If you're taking the Via bus, you're going to have to find some change. And if you're driving down, you're going to find that there's construction work, a lot of one-ways, and hardly any parking. And if you're lucky enough to find parking, you're going to find that parking is very expensive. So whether or not you have to come to the 187th District Court in person is completely up to you and your actions. To all the inmates at the jail, you're not allowed to use the chat box at all. Let me repeat that. You are not allowed to use the chat box at all. You are not allowed to use the internet at all. Again, you are not allowed to use the internet at all. You're not allowed to use Facebook. So all the inmates, if you just heard what I said, raise your hand to let me know that you've heard that. Mr. Hinojosa, are you a Spanish speaker? Because I don't see your hand raised. All right, I'm assuming Mr. Hinojosa is a Spanish speaker. But he recognizes his name. So inmates, don't do that. If you do, you're going to get sent back to your cell. What will end up happening, because you know they're shorthanded, we're going to see you in 30 to 60 days. So that will be your fault. To all the people on this Zoom screen, this is not The Bachelor. It's not The Bachelorette. This is not a time for you to try to pick up dates. If you want to pick up dates, you need to do that on your own time. I'm going to open up the breakout rooms. When I open up the breakout rooms, it will invite everyone to go to a breakout room. Do not, I repeat, do not go to a breakout room unless I specifically call you by name and assign you to a breakout room. To all of the defendants and those who are accused, when your attorney goes to a breakout room, your attorney is probably going to want to speak with the prosecutor before they speak to you. So please do not raise your hand asking to go to a breakout room. If your attorney wants you in a breakout room, they will request that you be sent to the breakout room and we will send you there. I'm going to call the attorney's name. I'm not going to call the defendants or those who are accused of an offense. I will not be calling your name. If you do not hear your attorney's name, do not worry, do not despair. That means that they're probably zooming in another courtroom or had to appear in person in a courtroom. So everyone put some patience in your pocket and just be patient. To all the attorneys, this is the order in which you'll appear. If you see you're at the low bottom of the list and you wish to zoom to another courtroom, you're more than welcome to do so. However, if you do so, and your name is called, you'll be placed at the end of the list. Miguel Hernandez, Scott McCrum, Nathaniel Navy, Roland Garcia, Ken Baker, Brian Kimbrough, Eric DeWalt, and Justin Fox. Is there anyone else whose name that I have missed? All right.
Ma'am, you missed my name. Were you gonna call my name?
Ms. Bagley, did you not listen to my instructions? Did I not say that I will be calling the names of the attorneys? I will not be calling the defendants' names.
Okay, I guess I was confused. Okay.
Everyone, this is what people always tell me, and I find it to be true. And sometimes I don't do this, right? People always say you were given 2 ears and 1 mouth, so you can listen more and talk less. I know as attorneys, we talk a lot. But please, everyone, try to listen to instructions, because if you do, things will move quicker. All right, attorneys, if you're able to change or add to your screen name the name of your client and whether or not it's criminal trial division or family violence, that will make things move along quicker. Attorneys, if you have a plea bargaining agreement, no matter how small that agreement is, you need to put it in the chat box to Norma Ferguson. She will be listed on screen as Ferguson coordinator. Please do not call her, text her, chat her, email her, asking for a continuance. I'm the only person who can give you that. Attorneys, when I assign you to the breakout room, think of those breakout rooms as a doctor's office. You're not seeing the doctor right away when they call you to the back. They're checking your weight and your blood pressure. The prosecutors have the ability to move throughout the breakout rooms. So if you leave that room, they will see that room is empty and they will skip over you. So the first one, Miguel Hernandez, who is your client, and is it criminal trial division or family violence?
Good morning, Your Honor. Criminal Trial Division, Mr. Deary. I've been out of the office, Judge, for a while because I got COVID. So I did not get a chance to go speak with Mr. Deary. So could I speak to him in a breakout room first?
Sure, I'll send you to breakout room number 2. And Mr. Deary, if you could go to breakout room number 2, please.
Thank you, Judge.
You're welcome. Mr. Deary, if you look on your screen, look at the bottom of your screen, Mr. Deary. Do you see where it's requesting you to go to a breakout room? All right, Mr. Deary, hold down the space bar. It's the longest key on the keyboard.
Oh, okay. There you go.
All right, so if you look at
Oh,
the
yeah,
bottom.
it says it now. It says it now. Yeah.
All right, if you'll go to that breakout room for me, please.
Okay, how I do that?
Oh, just click on it.
Just click on it. How I
Yes.
do that?
Okay, just one moment. Do you not have a mouse?
Yeah. Yes, ma'am.
All right, so
Okay.
move the mouse around. Do you see where the pointer is going on the screen when you move the mouse?
Yes.
All right, click on that
Okay.
for breakout room.
Breakout room. Okay.
Now, it's at the
Is it
bottom
a-
of your screen. Do you
Okay,
see at the
down
bottom
there?
of your screen where it says participants chat?
Participant. Oh, right here. Okay.
Okay, do you see
Okay.
breakout room?
And I just see participants.
And what else do you see?
That's it. Participants. I see participants. I see stop video, mute, chat, share screen, record, reactions. What else?
All right.
And more.
The deputy behind you, turn around and get the attention of the deputy who's right behind you. And tell the deputy you need to go to breakout room number 2.
I need to go to breakout room
Okay,
number
no,
2.
no
please.
problem. All you're gonna do is join right there.
Thank you. All right, Scott McCrum, thank you for changing your name. I'll send you to number 3.
Thank you.
Nathaniel Navy, thank you for changing your name. I'll send you to number 4.
Thank you, Judge.
Roland Garcia, thank you for changing your name. I'll send you to number 5. Ken Baker, thank you for changing your name. Oh, you have a question mark.
I think it's family violence, Judge. I'm almost positive. Sorry.
Oh, no
There's-
problem. Nothing hurts a failure but a try, and you are correct. I'm going to send you to number 6.
Great, thanks, Judge.
You're welcome. Brian Kimbrough, thank you for changing your name. I'm going to send you to number 7.
I want to let you know, I've been speaking to Meredith McIntyre.
And Meredith just came in. I think she got your vibes. So I'll
Good.
send,
I've been
So
having
I'll-
some internet issues at the courthouse, Judge. I don't know if you are.
oh, yes, we don't have Wi-Fi in certain places.
Yeah.
Oh, Michelle Hayden, I'm sorry. I thought I had made you co-host.
You did. I had to relog into Zoom. I got booted for some reason. Blame the
Okay,
internet issues.
okay. Oh, look like we have some gremlins working in the system. All right, so Brian Kimbrough, I'm gonna send you to number 7, and Meredith will meet you there.
Thank you.
You're welcome. Eric DeWalt, I'll send you to number 8. Thank you for changing your name.
You got it, Judge. Thank you.
You're welcome. Justin Fox,
Morning, Judge.
yes, who do you have?
I have Deshandra McAfee, Your Honor.
Deshandra who?
Deshandra McAfee?
Criminal Trial Division or Family Violence?
Family violence.
All right, I'll send you to breakout room number 9.
Thank you, Judge.
You're welcome. All right, Amir Mamorik, thank you so much for changing your name.
Judge, I'm here on Robert Andrade. Judge, I called pretrial services yesterday, got about 1, 2, 3 new numbers. I've called all the numbers I have, Judge. I am unable to get in touch with them. The numbers are disconnected, Judge.
All right, just give me one moment. And I will take that matter up. Matt Stohasky, he's connecting to audio. Matt Stohansky, who do you have?
I apologize, Your Honor. Ralph Petagoni.
Criminal Trial Division or Family Violence?
Criminal trial.
All right, I'll send you to breakout room number 10.
Thank you, Judge.
Amir, I usually give everyone till 10:30 to show up. Would you like to zoom out and zoom back in to see if he shows?
That's fine, Judge. You tell me what you want me to do. You want me to check back at 10:30?
Yes, if you could.
Will do, Judge. May I have excuse?
Yes, thank you so much for coming in.
Thank you.
Lorraine Efron.
Good morning, Judge. I'm
Good
sorry
morning.
for my
No
delay.
problem. Who do you have?
Joe Dela Cruz.
Criminal trial division or family violence?
Both. One is one of each.
Okay.
But I think CTD is kind of driving the plea.
All right.
Okay.
I'll send you to breakout room number 11.
Thank you, Judge.
You're welcome.
Hey, Judge, could Brian Kimbrough and I go into a breakout room with you to discuss something?
Yes. If you all will go back to breakout room number 7, I'll meet you in breakout room number 7.
Okay.
All right, Norma, can you see where Max Amandaris, what his ETA is, please, for me?
Yes, sir.
Okay, thank you. All right, Miguel Hernandez, what is happening with Mr. Deary?
Yes, Judge, I extended the offer from Mr. Sanders. Mr. Deary does not wish to accept it and does not want to make a counteroffer. I need to make sure I have all of the discovery. Just want to verify the videos of the bus, from the bus, because this happened on a bus. And so I would ask for one reset to get all that. Like I said, I was out the last 3 or 4 weeks or so, and so I hadn't done a whole lot on this one. So if I could get one more reset, I will have all the discovery done, and then we can get in the trial lineup.
All right, has the evaluation been completed?
Yes, Your Honor, he was determined to be competent for trial.
All right, Norma, if I could have a 30-day reset in the chat box for Mr. Deary for discovery, please. Just give us a moment and we'll get your reset date.
Thank you, Your Honor.
I'm sorry, Judge.
Yes, if I could have a 30-day reset on
Yes.
Mr. Deary in the chat box, please, for discovery. All right, we're going to come back on November 12th.
Thank you, Your Honor.
Thank you.
Yeah, we
Mr.
may-
Deary, your attorney is going to get the discovery that he needs. I'd like to make sure that attorneys have all the information so they can continue to proceed on your case. We'll be back on November 12th. Norman, can you let them know that L6 is excused?
Yes, ma'am. Thank you.
You're welcome.
Thank you, Judge. May I be excused
you.
also?
Yes, you're excused.
Thank you. Everybody have a good day.
Thank you. You too. Scott McCrum.
Goodbye.
Yes, good morning, Judge. We'd also like a reset, please. There's some discovery that had not been uploaded yet, and so Ms. Wilkes is going to provide that to me. We're also trying to track down a witness that would affect possible resolution.
Okay, I'm Mr. Eddington. This is the second time that I'll be resetting for discovery. So is there some issue with discovery? Is all the discovery there, but just not uploaded?
I don't recall what that last issue was specifically. I can tell you on this time, Ms. Wilkes said that there's a disk that she has found that hadn't been uploaded. So.
All right, so is that the only discovery issue?
To my knowledge, Judge, yes.
All right, Ms. Ferguson, can I have a 30-day reset on Mr. Eddington for discovery in the chat box, please? All right, we'll come back on November 12th for discovery. Is your client in custody or on bond?
On bond, Judge.
All right, where's Mr. Eddington? Your client is not on the Zoom screen, so I will not give a reset until your client appears.
Let me try to track him down, Judge.
Thank you.
Thank you.
Kenneth Baker.
Yes, Judge. I have conferred with the state. I'd like to convey their offer to my client, who's Ms. Coulterman.
Okay. You're in number 6. Is your client in custody?
Yes, Judge.
All right, we're just waiting for them to bring your client in.
Okay. Should I just go ahead and hang out in room 6, Judge?
No, if you'll wait on the screen, so that'll be, give me
Okay.
focus on you to remember to do that, okay?
Sounds good, Judge.
All right. Ms. Acevedo, you have Hernandez. Hernandez, I'm going to send you to breakout room number 1 with your attorney so that we can see if we have all your paperwork and so that you can be sworn in. And I'll send the clerks to breakout room number 1.
Thank you, Judge.
You're welcome. Anyone else back from the breakout room? Scott, you're back.
There he is.
All right, Brian Kimbrough.
Yes,
We're
sir.
just waiting. He is on his way up.
Okay, thank you, Your Honor.
So they have a seat for him. They're just waiting for him to come on screen.
Okay, yeah, I see the picture. Okay.
All right, Eric DeWalt.
Good morning, Your Honor. I just got back from a breakout room with the state and they made me an incredible offer and I'm very thankful for it. But the case that I had been dismissed and re-indicted at large. And I have tried every avenue to try to get a hold of my client. I've even called the court. We don't have his bonding agency. So currently my client is not here. I will continue to look for him. I understand if he gets picked up, then I'll know where he's at. But if I find him before that, I'm going to bring him to the court. But I'm kind of in limbo in the fact that we have tried every avenue to
All
try
right,
to
I give everyone till 10:30 a.m. So if you want to zoom out and zoom back in at 10:30 to see where your client is.
Your Honor, can I ask one favor, please? I have a parole hearing at 10 a.m., so I will log on the minute that ends.
Yes.
Thank you, Judge.
All right, you're welcome.
All right, bye-bye.
All right, Mr. Eddington, can you unmute?
Can you hear me?
Yes, I can hear you. Why are you late for court?
I'm sorry, ma'am. I had got an email, but I thought it was for a different client.
And I can confirm that. I checked the email I sent him, had one of my other clients' names on it, so I guess he thought it was sent to him by mistake.
All right, Mr. Eddington, your next court date is going to be November 12th. Do you understand?
Yes, ma'am.
All right, you and your attorney are excused.
Thank you.
You're welcome. All right, Brian, we're just waiting for your client to be placed in his seat. So give us a moment.
Okay. Actually, no, it's me.
Meredith, on Matt Stohansky's case, Ralph Pettigoni, does he need to go to that breakout room or no?
I went in there and Matt wasn't there.
Okay.
I can try again.
No, we'll see if he pops, if Matt pops out. Norma, I'm going to send you some information in the chat.
Yes, ma'am.
All right, Nathaniel Navy.
Yes, Judge. My announcement would just be, this is our first setting. There's quite a bit of discovery. I've gone through most of it. conferred with Marcus, and there's one particular surveillance video that I want to take a look at that I haven't come across. We were kind of coordinating so that I could go over to their office at some point next week and download it on a flash drive. So if I could just get a reset to complete my review of all the discovery and make sure that I have it all.
All right, and your client is on bond?
He is on bond, yes, Judge.
All right, where is he? Nicholas Cornelius.
No.
Okay. All right, Norma, can I have a 30-day reset for discovery on Nicholas Cornelius?
You said 30 days, Judge?
Yes.
It would. I'll put it in the chat.
All right, we're going to come back on November 12th.
All right.
And if there's nothing else, you and your client are excused, Mr. Navy.
Thank you, Judge. Appreciate it.
You're welcome.
I see Mr. Armendariz there, Your Honor. I think he's sitting in a chair.
No, he's not. I don't see him on the screen yet.
Oh, really? Okay.
Yes. I see his name in the box, but his face is not there.
Oh, I see. I've got it. Okay.
But they're bringing him down. Sometimes it takes a little bit of time depending on where they're coming from.
Okay.
Thank you for your patience. Thank you. All right, I have the paperwork on Dominique Hernandez. Is there a prosecutor available for this plea?
Judge, I'm not sure what it is, but I can handle it.
Thank you. Court is calling 2021 CR 8879, State of Texas versus Dominique Hernandez. Could I have parties announced for the record for the state?
Marcus Sanders.
For the defense?
Rochelle Acevedo.
And Mr. Hernandez, can you unmute? Are you Dominique Hernandez?
Yes, ma'am.
We're proceeding by video because of the pandemic. Any objections from the state?
None.
Any objections from the defense?
No, Your Honor.
Mr. Hernandez, I'm showing you what's entitled Defendant's Consent to Appear by Video Conference. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Defense, I'm showing you what's entitled Discovery Acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Mr. Hernandez, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, sir.
I'm going to need you to speak up.
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, it appears that you proceeded on lesser included offense of assault, bodily injury, family or household. Is that correct?
Yes, Judge.
Any objections?
No objection, Your Honor.
Mr. Hernandez, I'm going to show you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am.
Mr. Hernandez, do you have a sore throat?
No, I just got.
Then why can't you speak up?
I just haven't been asleep yet. Just tired. That's it.
Well, I mean, you need to talk so I can hear you and so that the court reporter can hear you. Do you understand?
Yes, ma'am.
All right, the lesser included offense of assault, bodily injury, family or household as a Class A misdemeanor. The range of punishment is up to 1 year in the Bexar County Jail and up to a $4,000 fine. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent.
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe he is, Your Honor.
Mr. Hernandez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am. I'm good.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Next, I'm going to show you the plea bargain page. Did you review that page with your attorney and did you understand it?
Yes, ma'am.
According to the plea bargain agreement, the state is proceeding on the lesser included offense of assault, bodily injury, family or household. Punishment is to be assessed at 150 days in the Bexar County Jail. Credit for time served, an affirmative finding of family violence, no harmful or injurious contact with Manuel Ortiz. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
You understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent.
Yes, ma'am.
Did you understand that to be the entirety of the plea bargain agreement?
Yes, ma'am.
Defense, is that the plea bargain agreement?
It is, Your Honor.
State, is that the plea bargain agreement?
Yes, Judge.
Next, I'm showing you the paragraph entitled Waiver of Appeal. Did you review that paragraph with your attorney? Did you understand it? Did you electronically sign it in both places?
Yes, ma'am.
Understand by signing that you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then to the lesser included offense of assault, bodily injury, family, household, how do you plead? Guilty, not guilty, or no contest?
I don't know. I don't know what to say.
Did your attorney want you
All
to
right. Are you pleading guilty?
Yes, ma'am. I think so.
Well, we're
Judge,
not vegan.
he's pleading no contest, Your Honor.
Oh, my bad. Yeah, no contest.
Yeah, ask your attorney if he wants you to share your.
I don't know. It's my first time in here.
How old are you, Mr. Hernandez?
23.
All right, this is not a game.
Yeah,
Do you understand that?
Reyes, come over here.
Yeah, I understand. I really am 23.
Yeah, but you're behaving like you're a toddler.
I really don't know. You know what I mean? Like, so when you asked that, I really didn't know what to say just now. That's it.
All right, so this is what I'm gonna do. I'm gonna send you to a breakout room so you can discuss with your attorney, because I want you to know what you're pleading to, and I want you to know what it means when you enter a plea. So I'm gonna send you to a breakout room with your attorney, and you can discuss that with your attorney. So if you can go to breakout room number 2, please.
Sir, I don't know if you got my sister's message yesterday.
All right, who is the attorney who was waiting on Almendaris? I believe that's Brian Kimbrough. Mr. Almendaris, I will send you to breakout room number 7, please.
Thank you.
You're welcome. And Norma, could you have someone take Mr. Hernandez to the breakout room number 2, please?
Yes, sir.
Mr. Fox, you're back.
Yes, Your Honor. Was in with Michelle. She is going to provide the court with a proposed order as to CPS records.
Okay.
Judge, I actually just sent a form that we have on Adobe. I don't think it's one that you can sign on Adobe, but it should be in your email.
All right, let me see what's in the email. It should go to the defense attorney. What I'll do is I'll just print it out. Of course, I don't have a printer, so I'm gonna have to have the clerks to print it out.
I'll send it to Justin right now too.
All right, thank you. All right, and then we'll reset this for discovery. That'll give you time to obtain those documents, Mr. Fox. Ms. Ferguson, can I have a 30-day reset for discovery in the chat box, please? On Deshandra McAfee. All right, so we're gonna come back on November 12th to see where we are on discovery.
Sounds good, Your Honor.
Thank you.
Thank you.
Is there anything else other than CPS records?
No, not at this time, Your Honor. I think once we get those, that'll be all discovery on this case. And it looks like we might be coming to a resolution soon after I'm able to review those records. So.
All right, thank you. Then you and your client are excused as soon as that document is printed out for me, because I don't have a printer we will take care of it.
Sounds good, Judge. Thank you.
All right, thank you. Have a great rest of your day. Ms. McAfee, your excuse will come back on November 12th, and it will be by Zoom.
Thank you, Judge.
You're welcome. Roland Garcia. Thank you. Oh, let me give this to you.
Hello, Your Honor.
Hello, just give me a moment, please. Thank you. Yes, Mr. Garcia, Gilliland,
Yes,
or
Your Honor.
Jillian, what's happening?
Your Honor, I conferred with the state on this with Mr. Hunter, or Mr. Morris, I should say. There are some, it looks like there's still some discovery that's outstanding, which he's going to work on getting to me. I did file a couple of motions regarding Mr. Gilliland's bonds, and we do have a partial agreement on those. He's currently remanded without bond on both of his cases. The state has agreed to setting bond on both cases at $5,000 each. However, they are not in agreement to a PR bond, which I would like the court to consider.
All right, just give me a moment. After I complete this plea, then we will take up that matter.
Thank you, Judge.
You're welcome. All right, Ms. Hayden, are you able to stand in on this continued plea on Mr. Marcus Sanders is back?
Yeah, either way, I'm here.
All right, I appreciate it. All right, we are back on the record in 2021 CR 8879. Mr. Hernandez, did you have a chance to confer with your attorney?
Yes, ma'am, I did. Sorry, I'm just really tired. I haven't been asleep. That's it. Don't mean no disrespect.
Right. Then to assault, bodily injury, family, household, how do you plead? Guilty, not guilty, or no contest?
Contest.
State any evidence to support the defendant's no contest plea.
Yes, Judge. State offers States Exhibit 1 and its attachments.
Any objections?
No objections, Your Honor.
Mr. Hernandez, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence States Exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there sufficient evidence to find you guilty, and the court will find you guilty of assault, bodily injury, family, household. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Judge, we're just asking the court to follow the plea bargain. He's been in custody since the inception of this case. I think it was July, I don't know if it's 18, but I believe he has roughly 90 days. So I believe that it should be a judgment satisfied. My client is young. I've explained all the consequences of having this conviction. He has his mother here, but his father is out of state. His father has made arrangements to have a family member pick him up from jail, and he's making efforts to try and get him, I believe, to Illinois. So he does have a supportive family. They've been reaching out for me, and we, obviously this is a pre-indictment. They're worried about him, and they're trying to just get him back on the right track.
All right, so I'm reading in the police report that they no longer want him at the address of this location. In the police report, it says that R1 stated that S1 was no longer welcome to stay at the listed residence. So where is he going to stay once he's released? Because I'm going to order that he not stay there.
That is his mom's house. So he's actually staying with a paternal relative until his dad can come and pick him up.
Okay. So there's no objections then to me ordering that he's not to stay at the, or be at the 114 Cravens Avenue address.
There's no objections to that. I've explained that he shouldn't go back there. And I guess just for the record, and for everybody's knowledge, he was arrested at the residence, and I believe all of his belongings are there. So at some point, I don't know if maybe the father can make those arrangements, but I have explained that someone else would have to go and retrieve all of his property from the home, but that he shouldn't go back over there.
Okay. All right, then this is what the court will sentence you to: 150 days in the Bexar County Jail, credit for any time served. There's an affirmative finding of family violence. There should be no contact at 114 Cravens, Cravens Avenue, San Antonio, Texas, 78223. And I see that you all agreed to no harm or injurious contact with Manuel Ortiz. Should there be contact?
Judge, that is his brother. So I think eventually, we would ask for no harmful injuries.
All right, I'll follow your agreement. You said no harmful or injurious contact with Manuel Ortiz. Is there anything else from either side with regards to sentencing?
No, Your Honor.
All right, Mr. Hernandez, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it, and did you sign it? Did you review that document with your attorney? Did you understand it, and did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Also, because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
All right, we can go off the record. Mr. Hernandez, it sounds like there was a lot of alcohol maybe involved in this. Stop drinking alcohol if it causes cloudy thought processes. You understand?
Yes, ma'am.
All right, Mr. Hernandez, good luck to you. If there's nothing else, Ms. Acevedo, we'll have Mr. Hernandez go back, or do you need to speak with him anymore?
No, thank you, Your Honor. Maybe
All right,
excuse.
yes. Norma Hernandez, 14-0 can go back. There are two people listed under 14-0, but it's Hernandez.
Thank you.
All right, are the parties ready on Gilliland?
Yes, Judge.
Yes, Your Honor, we're ready.
Okay. Mr. Stohansky, have you spoken on to to prosecutor on Mr. Pettagoni?
Yes, ma'am, we have. I don't believe we're going to be able to reach an agreement. And Mr. Pettagoni's tried 3 times to log on. He shut his computer down. He's trying to log on again. I've been on the phone with him.
All right, after he presents himself, then we'll take up this matter.
Thank you, Judge.
You're welcome. All right. Court is calling 2020 CR 3553 and 2020 4853 State of Texas versus Donald Gilliland. Could I have parties announced for the record, please, for the state?
Hunter Morris.
For the defense?
Roland Garcia for the defense, Your Honor.
And are you Mr. Gilliland? Just press the space bar. It's the longest key on the keyboard. Hold it down.
Sorry, Judge.
Yes, are you Mr. Gilliland?
Yes, ma'am.
All right, we're proceeding by video because of the pandemic. Any objections from the state?
None, Judge.
Any objection from the defense?
No, Your Honor.
Mr. Gilliland, do you have any objections with us proceeding by video?
No, Your Honor.
So first things first is discovery issues. Mr. Garcia, do you have all the discovery in each of these cause numbers?
I do not believe so. I have spoken with Mr. Morris, and he believes that he has located the discovery, which I have not received, and is going to make efforts to get that to me.
All right, Ms. Ferguson, if you could put in a date, just give 30 days on a date for discovery on this case, please.
And Judge, on that matter, it looks like it is a phone forensic report, and I just dropped that off downstairs. For some reason, it was printed. So that's been dropped off. And as soon as our paralegals can access e-discovery, we'll get that uploaded.
All right, so we're gonna come back for discovery on November 12th. And then after that date, if you have all the discovery, Mr. Garcia, we're gonna move towards a trial date.
Okay.
Now, the next issue is that the defense has filed motions in each of these cause numbers to, in 2020 CR 3553 to reinstate bond, and in 2020 CR 4853 to set bond. State, have you received both of those motions, and are you ready to proceed?
I have not seen the physical motions, Judge. I did talk about their contents with Mr. Garcia. I am ready to proceed.
All right. And what, before we start and I give defense the time to present their case, I just wanted noted for in the court's file, in each of these files, on March 8th, the defendant was a no-show, and it was recalled for March 18th, and the defendant was still a no-show. So defense, is there an agreement that's been reached on these motions or no?
We have a partial agreement, Your Honor. The state and I have agreed, or should I say the state has agreed to setting bonds in each of the cases at $5,000 each. What they are not in agreement with, what I would still like the court to consider, is release on a PR bond. Because originally he was granted a PR bond on both of these cases.
Okay, well, the issue would be the fact that your client did not show for court. So maybe those issues need to be addressed. Defense, you can call, do you have any witnesses?
I just have proffer that I'd like to make, Your Honor.
Yes, you may proceed.
So, Your Honor, at the time that the case were called for trial, Mr. Gilliland was homeless. His phone had been disconnected. He had no ways to contact me or for me to be in contact with him. There was already a warrant for one of the cases, the elderly case, the fraudulent case. That case had been indicted at large and there was an active warrant. You had granted a PR bond on that case prior to him getting booked. When he was then arrested around early March, I don't recall if it was before or after the 8th of March when the first FTA was put in, but he was arrested around that time. When he was released, Mr. Gilliland has advised me he did not receive notice from the jail of the next court date. And so on the 18th, he didn't have notice of that court date. I can tell you that between the 8th and the 18th, I did not have contact with Mr. Gilliland to advise him of the court date on the 18th. So I do not believe that he had notice to be in court on the 18th.
So when was your client arrested?
The records show that he was arrested on March 3rd. It looks like there was a,
If he's arrested on March 3rd, then why didn't anyone know where he was? Because
If
he
I
was,
may, Judge,
yes.
in cause 2020 CR 4853, it looks like he was initially booked on March the 3rd of 2020. He was subsequently released on a PR bond March 20th of 2020.
that's correct. I misread it, but it looks like on 2020 CR 3553, it looks like he was arrested on March 1st of 2021. He was released on bond on that. He was arrested on 2/28 and released on bond on 3/1/2021.
So he's saying that the jail did not tell him he had a court date for March 8th?
March 18th.
No. In each of these cases, he was scheduled on March 8th, 2021, and there was a no-show. And you would have appeared, counsel, because in my docketing sheet, I have recall for March 18th, 2021. So his case was originally set on March 8th, 2021. He was a no-show. And then I said, no bond forfeiture, none of that. We're going to recall it for March 18th, 2021.
Correct, Your Honor. The setting on March 8th was not a trial setting. What it was set for was he was arrested on February 28th. He was released on March 1st. On March 3rd, pretrial sent in a violation report for the arrest. And I think what happened was the court set a hearing on March 8th for a hearing on the violation report. And so when I appeared and he did not, it's because I didn't have contact with him to advise him of the setting. So the court recalled it for the 18th, and I still didn't have any contact with him. And so he had no notice of the setting on the 18th.
All right. State.
Judge, I would just note for the court the two particular offenses the defendant is charged with, understanding they're just allegations at this point, are both crimes of moral turpitude. So I'm skeptical that the defendant was unaware or made any attempts to make that court setting. That's why the state is opposed to a PR bond, but is in agreement to $5,000 each, and would ask this court to impose the same conditions of bond that were initially set by the magistrate.
And what were those previous conditions set by the magistrate?
Judge Valenzuela, Judge, and the cause ending in 4853 had initially included random UAs. And in the forgery case, Judge, we just asked for no contact with Mercedes Diaz. It's MERCEDES, Diaz, DIAZ.
All right, and the court is looking at the court's file, and on the violation report defense that the court has in its file is the fact that he never reported to the pretrial services offices.
Okay. I was just looking on the system and the system just said first violation report, rearrest. So it didn't list all of the alleged violations.
All right, is there anything else from either side?
Nothing from
No,
the state judge.
nothing from the defense.
All right, then, and cause number 2020 CR 4853, the bond will be set at $5,000. And I'll include random UAs. And then cause number 2020 CR 3553. Bond will be set at $5,000. Random UAs. And no contact with Mercedes Diaz. Mr. Gilliland, it's very important that when you're on a PR bond, that you actually report and that you actually show up for your court dates. And people know that they have court dates out there. They know they've been charged with something when they've been released. All you have to do is pick up the phone and call the clerks of the court. They'll let you know when your court date is. And if you don't have a phone, all you have to do is come down to the court. But I can't have people who have charges pending just not showing up at all and not doing anything, because then I don't know where you are. I don't take any of these cases as true because I don't have any facts that have been given to me about the case. But what I do know is that you need to show up for court. So now you know your next court date is November 12th at 9 a.m. You are either to appear on Zoom if you're released from custody or either in person at the court. The court is located at 300 De La Rosa. So if you're released, you are to appear by Zoom or either in person at 300 De La Rosa. If you're still in custody, we will have you brought over. Do you understand, Mr. Gilliland?
Yes, I do, Your Honor.
All right, thank you. Is there anything else from either side?
Nothing from the defense, Your Honor.
All right, we will
Nothing from the
close.
state judge.
Thank you. Norma, Mr. Gilliland can go back. He's 14-0.
Yes, ma'am.
And Mr. Garcia, if you have nothing else with us, you are excused.
Thank you, Judge. Have a good day.
You too. Brian Kimbrough, you're on Max Almendarez.
Correct, Your Honor.
Yes.
Yeah, we're ready. Well, I've talked to him. We're in agreement. We're ready to go. I don't know if he has to sign a acknowledgement on his appeal rights, but
Yes, he does.
yeah. So if you could send him that, I'll go back with him and.
Oh, if you put in the chat box to Ms. Ferguson what the agreement is, and she will get that to him.
Okay.
Thank you. And Mr. Almendarez, I'm going to send you to breakout room number 1 with your attorney, and he'll go over some paperwork with you. All right, Lorraine Efron.
Yes, Judge, I'm here.
Yes.
Okay, I have an offer that I need to talk to my client about, but sort of connected to that, of course, is that there may be some discovery that inadvertently was not uploaded to the e-discovery, some video and other things. So Caitlin was going to try to track that down, and she may have to make a disk for me. It may not be uploadable. That might be the problem. So there may be a little bit of discovery we don't have yet.
All right, Norma, on Dela Cruz, can you recall this for the end of October? Would that give you enough time, Ms. Efron and Ms. Wilkes?
It should, Your Honor. I've just requested, I guess, a service on the Veripic, so that I think Veripic is the issue right now. So I think, yes, to answer your question, Your Honor, yes, that should be enough time.
All right, Norma, on Dela Cruz. Yes, Ms. Efron?
Oh, I was going to say, is October 28th a possibility?
All right, Ms. Ferguson, can we call this back on October 28th?
Yes, ma'am.
All right, we will be back on October 28th. Mr. Dela Cruz will come back on October 28th, and we will make sure that your attorney has all of the discovery. Do you understand?
But can I have a moment, because I haven't heard no plea. She said there was a plea offer and I haven't been offered none. Because I've been
All right,
coming to
well,
the
just a
court.
second before we go then, I'll let your attorney tender the plea to you. And Ms. Ephraim, we may not need to come back on that day.
That's true. Let's see.
All right, so
Thank you.
Ms. Ephraim, thank you, Mr. Dela Cruz, for letting me know. I'm going to send you to breakout room number 2. And Mr. Dela Cruz, if you'll go to breakout room number 2, please. And then Kenneth Baker, Ms. Coulterman is here.
Great, Judge.
I'm going to send you to breakout room number 3.
Okay.
And Ms. Coulterman, if you could go to number 3. And then Matt Stohansky, your client, Patagoni, is here.
Yes, ma'am.
Right. So what is happening with Patagoni?
The state has tendered an offer. My client does not want to accept it, so we're going to need a trial setting.
All right. Who is the prosecutor you're conferring with?
Meredith?
All right. So what have you received all the discovery in this case?
Yes, ma'am.
All right. So what I'm going to do is I'm going to send you to breakout room number 4 to get a trial date from Miss Ferguson.
All righty.
And I'll send Meredith to number 4 as well.
Thank you, ma'am.
You're welcome.
Have a good day.
Thank you. You'll need to come back to put it on the record. Orlando Castagnon.
Yes, Judge, I'm
Uh,
present.
All right, can I see you in breakout room? I'll send you to breakout room number 5. All right, Kathy Compton. Thank
Good
you.
morning, Judge.
I'm going to send you to breakout room number 3. A prosecutor will meet you there.
Thank you so much.
All right, thank you. Eric Baker on Coulterman, where are we? All right, I think he is. All right, he's still out. Oh, Ken Baker, where are we on Coulterman?
Judge, I think we have a disposition. I did send a chat to Michelle just to tweak a little bit. I think she'll be okay with it, but even if not, we've got a plea. But I was looking for Norma on the chat to send her the plea, but I couldn't find
Oh,
it.
she was in a breakout room. So whenever you go to a breakout room, you can't see us.
Oh,
so
okay.
if you could send that, chat it to her, she'll get that paperwork ready for you.
Certainly.
All right, then I will send I'll send you and Ms. Coulterman back to a breakout room so you can receive paperwork, but you say you need to speak with Ms. Hayden first.
Well, I just want to know if she got my chat and if she's okay with.
I did get your chat. Can I talk to you in a breakout room again?
Of course, yes.
All right, I just sent you to breakout room number 4, Mr. Baker.
Okay. Okay.
All right, and Brian Kimbrough. Amandaris is still in breakout room number 1.
Yeah, we're still waiting for that paperwork. I texted Norma. I was going to text her again.
It's coming through, Mr. Kimbrough.
Okay, so thank you.
And the day has the feel of a Friday, Brian, but our computer system is saying it's Monday. So Wi-Fi is going in and out.
Yeah, I understand. I'm going to go to the breakout room.
Okay. All right, Kelly McGinnis, you're here on Bagley. You're on mute. But
Yes,
I will.
Judge, I am, and for Charles, he's actually here next to me. We're at the courthouse, so.
Okay. Hi, I'll see you to breakout room number 5.
Okay, thank you.
You're welcome. And that case on Bagley is criminal trial division.
Did you say number 5 or something? Am I supposed to go somewhere?
No, you're not supposed to go to number 5. I mean, you keep asking those questions, Miss Bagley. I'm thinking that you're not listening to the court's instructions.
Only when you call my name.
Mhm. All right, Mr. Baker?
Yes, Judge, we're ready. I chatted Norma the plea agreement.
All right,
For,
I will send you, then your client, I will send her to breakout room number 4. And if you could go back to 4.
Will do, Judge. Thank you.
You're welcome.
Judge, it's Rebecca. I just sent you a chat.
Got it. Thank you.
Judge, can I break out with, or Marcus, can we break out again in a room without my client?
Yes.
Okay, thank you.
I'll send you to number 6.
Okay, thank you. What the
Yes, Mr. Bach.
Okay, Judge, I'm gonna ask if we can reset my case for a plea, but I have a question. The
Yes.
plea is going to involve a MyOff evaluation, and I can't recall if they'll do the evaluation in advance while we're waiting for the plea, or if she has to plea first.
Just one moment, the probation officer is zooming back in because we have Wi-Fi issues, so she'll be able to let us know. Rebecca, are we able to do a MyOff evaluation prior to entering a plea?
I think just with the PSI.
So only with the PSI.
Okay, well then if I can reset my case for 2 weeks for a plea, and but just letting the court know, part of the plea is we're gonna have to require a P. I actually set it for 1 week since we're gonna have to wait for the PSI anyway. If we can plea the end of next week, then we'll order the MyOff and all that as soon as we get the plea done.
Right. Ms. Ferguson, could you give me a date for next week for a plea on Ms. Rosalind Bagley?
Yes, ma'am. Oh, what is wrong with my computer? Hold on, Judge.
Yeah, we did.
I can do the 15th, Judge, or the 13th or the 15th.
All right, 13th or the 15th, Charles.
Let's do the 13th. The 15th looks terrible on my calendar.
All right, we'll come back on the 13th.
Okay, may I break out with her again, and then do you need to excuse her from here? Or
Yes,
can I break
need
out with
to
her and excuse her?
from the main room.
Okay, can I break out with her and then I'll bring her back to you?
Yes, I'll
Okay,
send you
thank
to
you.
breakout room number 5.
Thank you very much.
All right, Brian, we are ready on Mr. Almendarez.
Yeah, I'm ready, Your Honor.
Thank you. Brendan, you know, I think the system just may be a slow system. All right, the court is calling 2020 CR 10710, State of Texas versus Max Anthony Almendarez. If I can have parties announced for the record for the state.
Meredith McIntyre for the state.
Brian
For the
Kimbrough
defense.
from Mr. Armendariz.
And are you Max Almendarez?
Yes, ma'am, I am.
We're proceeding by video because of the pandemic. Any objection from the state?
No, Your Honor.
Any objection from the defense?
No, Your Honor.
Mr. Almendarez, I'm showing you what's entitled Defendant's Consent to Appear by Video Conference. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am, I did.
Court will find that defendant has knowingly and voluntarily consented to appear by video conference. Next, I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that document with your attorney? Did you understand it? And did you did you understand it?
Yes, ma'am.
Okay, just one moment. I'm trying to multitask for now. All right. Are you the same Max Anthony Almendarez who was placed on deferred adjudication and cause number 2020 CR 10710 for the offense of assault on a peace officer or judge, bodily injury on January 13, 2021 for a period of 8 years? Is that you?
Yes, ma'am, it is.
All right, state.
On or about the 31st day of May 2021 in Bexar and/or Guadalupe County, Texas, the defendant, Max Anthony Armendariz, did then and there fail to provide installed verification of the SCRAM device in violation of condition number 15.
How do you plead to that, true or not true?
Plead true.
Court will find violation of condition number 15 true. State.
We'll waive the remaining violation.
Any objections?
No objection.
Mr. Armendariz, did you understand him by pleading true to violation of condition number 15? The court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison. Did you understand?
Yes, ma'am, I do.
Knowing that, do you still wish to plead true to violation of condition number 15?
Yes, ma'am.
All right, is there an agreement? The court will find violation of 15 true. Is there an agreement?
There is, Judge. We're asking the court to deny the motion, continue him on his deferred adjudication, alter and amend his conditions to include a felony drug court referral.
It's correct, Your Honor.
All right, the court then will follow the agreement, deny the motion, alter and amend conditions to include a felony drug court referral. Defendant is to remain in custody. Until accepted into drug court. And Norma, I'll need a date. If I could have a 20-day reset just to see where we are on this referral. And if we could not put it in the system, because then it'll show up that he has a pending case and they want to accept it. All right, we're going to come back then on October 22nd. All right, and we'll see if we can't find a placement for you, Mr. Armendariz, okay?
Thank you, ma'am. Appreciate your time. Have a blessed day.
All right, thank you. Oh, you have a blessed day too. But before you go, I'm going to send you to a breakout room so probation can go over conditions with you, okay?
Judge,
All
I'm
right,
sorry. Can we change it to the 25th, Judge?
Okay, so it'll be October 25th.
Yes, ma'am.
Ken Brown.
Your Honor, I can be dismissed. I was done with my attorney.
And Mr. Armendariz, if something happens before then we'll take care of it before then.
Yes, ma'am.
So
Sounds good.
I'm going to send you to breakout room number 1.
And I can be excused, Your Honor?
Yes, you can be excused.
Okay, and I'll see you Monday. Okay, thank you.
All right. I'm sorry, Mr. Armendariz, you know what? Let me move you to number 2. And probation will meet you in breakout room number 2. All right, Eric DeWalt, Mr. Williams has not made his appearance.
Your Honor, I just finished my parole hearing. Thank you for allowing me to do that. And I found 3 more phone numbers and I've exhausted all of them. So yes, Your Honor, my client is not here right now.
All right, we can do 1 or 2 things. We can take this matter up now, or if you want, I can recall it for tomorrow because I know you were just given those new numbers today.
Stuff. I can send him some more.
Your Honor, tomorrow at what time?
It will be at 9.
Can I log on at 10, please?
Yes. Okay.
I have a 9 o'clock hearing and I can log on at 10 and I appreciate the 24 hours to try to get a hold of my client. Thank you.
All right, you're welcome. So I'm going to note on the docketing sheet that your client was a no-show as of 11. And we're going to recall it tomorrow for 10 a.m.
Will I get a new Zoom hearing or?
Yes, you'll get a new Zoom link. Ms. Ferguson, on Williams, it's going to be recalled for tomorrow at 10.
Yes, ma'am.
All right, you are excused.
Thank you, Judge.
You're welcome. Lorraine Efron?
Yes, Judge.
Yes.
I'm done conferring with my client, and I was wondering if I may be excused.
All right, what date are we need to have your client come back to the main room?
He did come back, Judge. You gave him a date already for discovery on October 28th.
All right, we'll see you back on October 28th.
Thank you, Judge.
Okay, Charles Blanc, you have your hand raised. Ms. Bagley is back. Norman, can you let them know 13B
Judge,
is back?
I do. We've had a change. Strategically, we changed our position. We're not going to need the setting on the 15th or the 13th. We're going to ask for a 30-day setting.
Okay, why are we getting a 30-day reset?
Marcus is going to reach out to his complainant and see if we can't find an alternate resolution.
All right, to the clerks, could you bring me the paperwork back on Ms. Rosalind Bagley?
I apologize, Judge.
No problem. It's still Thursday. We're close to the end of the week, so everyone should still be happy.
I'm always happy.
So on the 30-day reset, this is going to be dispositive?
I hope so. Well, that's up to the complainant, I suppose, and Marcus, but I mean, I'm hopeful.
All right.
I don't want to promise something I can't deliver, but I'm optimistic.
All right, Norma, can I have a 30-day reset on Rosalind Bagley?
Right? No,
no, it's not in the chat. The only chat I have is October 28th.
Oh, I'm sorry. One second. Where is it? Let me get my.
Can I speak to you too, lawyer John? Mr. John?
Okay, we're going to come back on November 11th, Mr. Bonk.
Yes, Judge.
All right, Norma, you can let them know Bagley can go back. She's 13B.
The 11th is Veterans Day. I don't think we.
Thank you, Brenna. Charles, it's going to be November 12th.
Okay, that's fine. Thank you.
Thank you, Brenna. All right. Norma, I need to know where Tony Jimenez is on Mr. Hinojosa.
Judge, I'm still trying to get a hold of him.
All right, we're going to recall Mr. Hinojosa for tomorrow. So on Hinojosa, we'll bring back that tomorrow, Norman.
Yes, ma'am.
Because he requires a Spanish speaker. And so we need to have attorneys here on time to make sure we get the Spanish speaker done. Because they are limited. And let me see where Kathy Compton is.
Good morning, Judge. So,
yes.
Marcus and I have conferred. We pretty close to working this out. So if you would be okay with it, could we possibly be recalled or reset to like Monday or Tuesday next week? There's a couple of loose ends that I need to tie up on my side of things. But I think that we can have everything done and ready to roll on Monday or Tuesday next week.
All right, Norma, can you recall Ms. Rodriguez for Monday?
Yes, ma'am.
And I think that I left her in a break room, Norma. If she's still there, you can pop me back there. And if you're okay with it, Judge, I'll just leave from the break room.
You can leave from the breakout room, but she'll need to come back to the main room. And so we'll be back on Monday, the 11th.
Okay, I'll let her know too.
And I'll send you, let me see. All right, and then that just leaves Kenneth Baker on Coachman. They're in a breakout room. Let me see where they are on paperwork. All right, are the parties ready to continue on Salazar?
It's ready, Judge.
Okay, and Norma, if you can let them know that Hinojosa 14N can go back, please.
Yes.
All right, we're back on the record in night bank number 618564. Could I have State of Texas versus James Ross Salazar? Can I have parties announced for the record for the state?
Hunter Morris.
For the defense?
Barry Hitchings, attorney for the defendant, James Ross Salazar. We're ready.
And are you Mr. Salazar?
Yes, ma'am.
And also we have Stephen Gilmore, who's attorney for the witness, Cassandra Lopez. We're proceeding by video because of the pandemic. Any objections from the state?
None from the state, Judge.
Any objections from the defense?
No objections, Your Honor.
Mr. Salazar, do you have any objections to this hearing continuing by video?
No, ma'am.
All right, and I believe where we left off from yesterday, Ms. Lopez was having problems with Wi-Fi and she was on the witness stand. So Ms. Lopez, even though you're still under oath, I'll just swear you in again out of the abundance of caution. Could you raise your right hand for me? Do you solemnly swear and affirm that the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, if you could lower your hand and state your name for the record.
Cassandra Lopez.
Okay. And also the state had invoked the rule. Are there any other witnesses who are present?
I'm not aware of any, Your Honor, for the defense.
All right, then I believe, were we still on direct examination, Mr. Hitchens?
We were, and I'll announce at this time I've got no further questions on direct examination for witness Cassandra Lopez, Your Honor.
All right, then state.
Thank you, Judge. I'm Ms. Lopez. I'm Hunter. If I speak too fast or you don't understand a question, please just ask me to repeat myself. Happy to do it.
Okay.
So in this case, I believe Mr. Hutchings was asking you about the vehicle being stolen, and you had mentioned that you had some pills and wandered upon the keys. Is that right?
Right.
Okay. And in the offense report, I guess first, Judge, I provided to this court and defense counsel states exhibits 1 through 4. 2 of those, states 1 is an offense report, states 2 is history. The the state does not want to admit states 3. It's just for the council and court to review if desired. And then states 4, the state would move to admit 1, 2, and 4 for purposes of this hearing.
Any objections to State's Exhibit number 1, defense?
No objections, Your Honor.
State's Exhibit number 1 is admitted. Any objection to State's Exhibit number 2, defense?
No objections on number 2, Your Honor.
State's Exhibit number 2 is admitted. Any objection to State's Exhibit number 4?
No objections, Your Honor.
State's Exhibit number 4 is admitted into evidence.
Thank you, Judge. Now, Ms. Lopez, I'm looking at State's Exhibit number 4, which is the offense report for the unauthorized use of a motor vehicle. And it has an incident location, and it provides a home location for you. I won't say it live on YouTube, but it looks like it's somewhere close to Highway 37. Is that right? Is that fair?
Correct.
Okay. And is that inside Loop 410?
Yes.
Okay. Where about in San Antonio did you work at the time? Do you remember?
I wasn't working.
You weren't working. Did you have any family or friends that maybe lived on the east side?
I did.
Okay. Because the offense report shows that the theft occurred east of 1604 on the east side. And you stated that you were walking along, kind of didn't remember where you were on some pills. Is there any reason you would be wandering down Loop 1604 on the east side?
I had caught the VIA bus and I had gotten off because I didn't know where I was at. I had gotten on the wrong bus and I had started walking to figure out where I was. And I would say I was walking for about an hour, and that's when I came upon the keys.
And what kind of Kia was it?
I'm sorry?
What kind of car was it?
It was a 2012 Kia.
What kind of Kia?
2012 Kia.
Kia what?
I don't know. I just saw the Kia on the front of I saw the sign of the Kia on the front of the car.
Okay. And why did you call police out to the park?
Because me and my husband were arguing, and he no longer wanted to be with me. So I was upset about the fact that he no longer wanted to be with me. So I called San Antonio police to come to the park so that I can explain to them that he hit my son, which was false.
How long had it been since you saw Mr. Salazar?
It was like a month. I hadn't seen him.
And what car did you arrive at the park in?
We arrived in the Kia together.
Do you remember having a separate car?
I do.
So there were actually 2 cars at the park, right?
No.
There weren't 2 cars at the park.
No, there wasn't.
Do you remember telling officers that you arrived in your own car? You met him at the park?
I did not.
Do you remember telling officers that he arrived at the park in the Kia?
No, I don't. I said we were together.
You said you arrived together?
Correct.
Do you remember talking on the phone with officers about the incident?
I do.
Judge, permission to publish State's Exhibit number 4.
No objection.
No objection.
You can, I'm sorry. Yes, you may publish State's Exhibit number 4. It has been admitted to evidence.
Thank you, Judge. So I'm showing you, can you see this highlighted portion here, Ms. Lopez?
Yes.
Okay. You see here they're talking about having a conversation with you on the phone.
Correct.
You told them on the phone that you drove out to where James was. And then you got into the car that James told you he had bought and drove to the park. You see that?
Correct. which was the car that I was driving, which was the Kia 2012 Kia. I had drove to where he was at, and together we drove to the park.
Okay. You go on to tell the officer that you asked James how long he had the car, or you weren't sure how long he had the car, but that he mentioned about 5 days. Do you remember that?
I do.
That James had it 5 days.
Correct. But
And you hadn't seen James in how long?
over a month.
All right. And the car was reported stolen 5 days before.
Correct.
So James had the car for about the length of time that it had been stolen, but you hadn't seen James in about a month. Is that right?
No. No.
That's not right.
I hadn't seen him for about a month. But whatever I was saying in the statement, I swapped it from whatever I did and I put it on him.
So you had the car for 5 days.
Correct.
Oh, okay. So you lied to the police officer.
Correct.
Okay. And then what did you tell the police officer happened in the car?
I told the police officer that he reached over and smacked my son in the face 5-6 times, and that was false.
And this car seat was in the Kia, is that correct?
My daughter's car seat.
Your daughter's car seat. And was she positioned behind the passenger side or the driver's side?
She was positioned behind the driver's side.
Behind the driver's side. And what seat was James sitting in?
He was sitting in the passenger side.
And did the officers show you the images taken of your daughter?
No.
Did they tell you that there was redness and a scratch and swelling to the eye?
Correct. But you got it mixed up. My daughter wasn't involved in the incident. It was my son.
Oh, okay. Where was your son sitting?
My son was sitting in the middle.
Of the back seat?
Correct.
So it was your son's picture that was taken?
Correct.
And he had the swollen eye?
Wasn't a swollen eye. It was just a tiny little scratch on his face.
Okay.
On his right eye.
Were they both in the car with James when you stepped out of the car?
I'm sorry?
When you stepped out of the car, were both your son and daughter in the car?
Correct.
And the baby woke up, the son. And then you told the officer that this upset James, and so he struck the child. Is that right?
Correct.
And you're now telling this court that you made that up.
Correct.
But the child did have some redness to the eye. Is that right?
Yes, he did, but that happened the night before when he was playing with the broken chair and he had slipped through it.
And it happened to hit him on the eye right where somebody reaching back would have had access to somebody's face if they were upset with them.
If I may, if somebody were to hit as big as my husband's hand, if he were to hit him 5-6 times in the face, there wouldn't have just been a scratch on his face. There would have been bruising.
Which the officer noted, correct?
Which was a tiny, no. He marked that there was a tiny scratch on his right eye.
So you're saying that didn't happen. Your 1-year-old was not assaulted by James.
Correct.
Now, Cassandra, you've been the listed witness in some cases with James before, haven't you?
Correct.
Where he assaulted you. Is that
Correct.
correct? And he hit you with his hand, is that correct?
Correct.
Have there been any assault cases to your knowledge between him and his father?
Correct.
What about him and his sister?
No.
No?
No.
So it's your testimony to this court that you stole the vehicle and that you also made up this story about hitting the child.
Correct.
My final question to you, Cassandra, is why are you defending him?
I'm not defending him. I'm coming out and simply telling the truth about what happened because I don't want an innocent man going to jail for something that he didn't do.
Pass the witness, Judge.
Okay. Any follow-up questions? Any redirect, Mr. Hitchens?
I've got no follow-up, recross or redirect examination questions of this witness, Cassandra Lopez, Your Honor.
All right. Is this witness excused or subject to recall?
She can be excused as far as I'm concerned.
State's done with her, Judge.
All right, Mr. Gilmore, then your services here are complete. Thank you so much for being here yesterday and coming again today.
No problem. Happy to do it. Hope I accomplished something.
All right. Thank you so much.
All right. Y'all take care. Appreciate y'all.
Thank you, you too.
Bye.
Mr. Hitchens, any further witnesses?
No further witnesses, Your Honor.
State, any witnesses?
None, Judge. Just
All right,
state's
then-
exhibits.
All right. Then the court will hear argument. Defense, it's your motion. You may proceed.
Your Honor, if it may please the court, in the motion to modify bond conditions, initially we point out that James has been in jail. This unauthorized use of a motor vehicle is remand without bond, so he's not able to make bond on the unauthorized use of a motor vehicle. He does have another pending case, and that's what the prosecutor had referred to, an assault family choking. That's a second-degree felony. That bond is set at $40,000. In state's exhibit number 3, not 3, but number 2 that was admitted in the evidence. There was talk about the injury to a child case. State's exhibit number 2 indicates the grand jury cause number 752457, which is an injury of a child with intentionally causing bodily injury. That event happened on June 13th, 2021. And about 3.5 months later, according to state's exhibit number 2, the case of injury to a child against James Salazar was closed by the state. That's reflected in state's exhibit number 2. So we're not dealing with 3 cases, we're talking about 2 cases, the unauthorized use of a motor vehicle and a pending case of assault, bodily injury, choking, which bond is set at $40,000. And so we're down to these 2 cases. In the motion to modify, we point out that, and testimony was provided by Cassandra Lopez on these facts, that her son, during James's incarceration, her son and James' son, 1-year-old Joel Salazar, had been hospitalized in San Antonio North Central Baptist Hospital for COVID-19. That's extremely difficult when a 1-year-old child comes down with COVID-19. And certainly James is very concerned about the welfare of the child. Thankfully, the child is at home with the mother right now. He successfully was treated at the North Central Baptist Hospital. Also, the defendant, James Salazar's father, Ronnie Salazar, is in the San Antonio Downtown Baptist Hospital. And from reports I had received and what Cassandra Lopez testified to, he also has COVID-19, and James is very concerned about his father. Now, with respect to the unauthorized use of a motor vehicle, Cassandra Lopez's testimony is that she found the keys to the Kia. It's a 2012 Kia. In the offense report, it's described as a Forte, Forte. She didn't know the particular model. She knew it was a 2012 Kia. She admitted to taking the keys and starting the Kia Forte. She was wrong in doing that, and I think she recognizes that she was in fact wrong. And she, in her testimony, she had told the defendant, James Ross Salazar, that she had bought the Kia Forte from someone else. And of course, she's wrong to do that. That's not true. She admits that she had stole the 2012 Kia. James was led to believe that this was his wife's or common law wife, Cassandra Lopez vehicle. And then they get to the, I think it's called Walker Ranch Park, where they're going with their children to be able to relax and kind of a picnic. And then comes the claim that, and the two cases kind of merged together, where she made a call to the police department saying that her husband, James, had struck their 1-year-old son 5 to 6 times across the right side of his face. Well, she admits that was wrong. She was upset with her husband, James, because James, according to her testimony on cross-examination, didn't want to be with her anymore. And so that's what prompted the call to the police. She was wrong to do that. James, as she testified, left in the 2012 Kia as she had called the police. And then later James was apprehended. I believe it was at the location where his father was. She did a lot of wrong things, but ultimately, I think she did the right thing as she testified on cross-examination. She, in response to the question, why are you defending him? She answered, well, she was responsible for these 2 cases being reported to law enforcement with regard to the unauthorized use of a motor vehicle, and then subsequently the injury to a child case. She was responsible for calling the police and not telling the truth as far as James allegedly striking his son. She didn't feel it was right for an innocent man to be in jail on based on facts that she knew were not true. And she wanted to right the several wrongs that she had previously admitted to. I think when you look at these 2 pending cases, the unauthorized use of a motor vehicle where bond is remand without bond, the other remaining case is set at a $40,000 bond, a second-degree felony assault, family violence. I think James is clearly entitled to having the remand without bond vacated on the unauthorized use of a motor vehicle. We would request that a reasonable bond be set and that he be allowed to make a bond. I think the testimony that the court has heard shows that James is deserving of a bond setting on the state jail felony case of unauthorized use of a motor vehicle. Without all of this testimony, this was a situation where a defendant had an unauthorized use of a motor vehicle state jail felony, and he had a case of assault, choking, family violence, second-degree felony. I think if we just didn't have all of this other testimony out there, just a fact that state jail felony, unauthorized use of a motor vehicle, assault, family violence, choking, where bond is set at 40,000. I suspect that in any other case, he would have a bond, and it would not be remand without bond on the state jail felony. And we would request that the court vacate the remand without bond and set a reasonable bond for James Salazar to be able to make on the unauthorized use of a motor vehicle. And I've got nothing further, Your Honor.
All right, State.
Thank you, Judge. I'm not here to litigate whether or not this case can be proven, Judge. I would note that the witness, for some reason, takes via buses to the outskirts of town and wanders around aimlessly, high on pills, and then is able to create very elaborate stories for the police. When it makes logical sense when you look at the photographs admitted at stage 3, that the incident happened exactly as she initially described it. I also believe a reasonable bond should be set in this case, Judge. So we would ask for a $10,000 bond in the UUMB case, as well as a no harmful or injurious contact order with Cassandra Lopez and the children.
And who are the children?
Well, there is Joel Salazar, who is now about 1.5 years old.
All right, and could you spell the first name for me, please?
Joel, Joel.
And the other child, please?
The other child, I'll need to look in the report.
Mr. Salazar, what is the other child's name, please?
Ronnie Salazar. That's my daughter.
Is that Ronnie?
It's only with an I, no E.
And it's Ronni or Roni?
Yes, ma'am. Ronni Salazar.
All right, I'm sorry, State, what amount of bond are you requesting?
10,000, Judge.
All right, and defense, what amount of bond are you requesting?
We would concur with a $10,000 bond setting, Your Honor.
And where are the children currently?
I think, although I'm wouldn't know for certain, that way I wish Cassandra was still with us. I believe they're still with their mother, Cassandra Lopez.
Right, does anyone know is Child Protective Services involved?
They were involved, Judge. I have not reviewed the report, but there is a report.
All right, if there's nothing further, this is what the court will do. The court will set your bond at $10,000. There's to be no contact with Cassandra Lopez, Joel Salazar, Ronnie Salazar. Does anyone have the address of Miss Cassandra? I believe it may be in the exhibit, but I want to be sure that I have her proper address.
You want me to message that to you, Judge, or say it out loud?
No, I mean, is it the 521 Virginia?
Yes, Judge.
There's to be no contact with 521 Virginia Boulevard.
Yes, Judge.
78203. Is there anything else from either side with regards to the court's ruling?
Nothing from the state, Judge.
Just, Your Honor, I understood the state to be asking for no harmful or injurious contact with Cassandra or the family, but now the court's making it no contact?
Yes, I'm saying no contact. I don't know where the children are. Mr. Salazar, I look at cases, I listen to testimony. You should not be having any contact with Cassandra Lopez, Joel Salazar, or Ronnie Salazar. Now, if the children are in care of Child Protective Services and they're in the foster care system or with a foster parent, then the court may consider changing the no contact order with Cassandra Lopez. But what I'm being told is that she has the children in her care. And if that is the case, Mr. Salazar is not to have any contact with Cassandra Lopez. So what this means, Mr. Salazar, is you are not to phone, you're not to email, you're not to instant message or whatever media format that young people are using these days to contact Cassandra Lopez. And you're not allowed to do it through a third party. So your parents, your cousins, or whomever it may be, cannot deliver messages from you to her, to the children. Do you understand?
Yes, Judge.
And if there is a Child Protective Services case pending and ongoing, then you probably need to do your service plan.
Okay.
We can go
Yes,
off the
Judge.
record. Mr. Salazar, here's the thing. Children don't ask for whom their parents are, right? There's not where they can say, well, I'm looking down below and I see these two people. These are who I want my parents to be. It's luck of the draw who your parents end up being. So if Child Protective Services is involved, then that means that you have items that you need to complete on your service plan, which is probably parenting and everything else, getting a job and all these other things. You're an adult, children are children. Children cannot be taken to a park and just say, I birthed you, I'm your father, I'm your mom, go forth and support yourself. That's a parent's job. And when it's supporting them emotionally, physically, mentally, all of those things, because children can't support themselves. So my job as a judge, when I give people bond, is to make sure that society is protected as well. So based upon what I've heard, there needs to be a no contact order with Cassandra Lopez, Joel Salazar, and Ronnie Salazar. You understand?
Yes, ma'am.
All right, is there anything else? If not, we'll send Mr. Salazar. Yes, Mr. Salazar.
Yesterday I was hearing you talk about a flower to this man, and he said to get this flower and it takes about a year for it to bloom. I wanted to know what flower that was again.
It's an orchid. And let me just tell you, when
orchid.
you go to the grocery store and you get an orchid, because they're selling it, it's all beautiful. It's blooming. And it will have a bloom on it for about 2 months. Then after that, the blooms will fall off. You've got to keep that orchid for a year and have it bloom again. And if you're able to do that, I'm like May, I'm not going to say for sure, you may be ready for a relationship, because orchids require patience. It requires sun. I have an orchid here that the staff got me. I'm waiting for it to bloom. I have this little leaf. Maybe it's going to do something. I don't know. I got to be patient. As you can tell, I love flowers in my office. I'm not going to throw this away, because guess what? It's important and it means something to me because my staff gave it to me. So I'm working on trying to get it to bloom. And with orchids, guess what? They say you can't water it too much. You can't put it in certain types of sunlight. You can't move it around enough. The fact that I'm showing it to you right now, it's probably causing significant harm to it. But I want to let you know it is not easy. But if you are able to get it to bloom another year, now mind you, I've been waiting 2 years for this to rebloom, so it hasn't happened. So you have to wait and make sure, and then maybe, not for sure, maybe you'll be ready for a relationship. You understand?
Yes, Judge. Thank you so much. God bless you.
No, thank you. God bless you too. I'm going to send you back. Norma L17 can go back. Mr. Hitchens, we are done for today and you are excused.
Thank you, Mr. Hitchens.
Just keep getting tastier. And away.
Okay, so the only other case we're waiting on Coulterman with Kenneth Baker and number 4. As soon as the court receives that paperwork, I will sign it. And we will proceed. And I'm going to take a 5-minute break. All right, everyone, we're just waiting for the paperwork on Coulterman. I believe Mr. Baker is going on that, over that paperwork, so I'm just going to check to see where they are. Kenneth, let me check and see if I received the completed email.
Certainly, Judge.
Okay, this is what I'm going to do now. Since I closed the breakout room to help you get out, Ms. Coulterman, I'm going to open the breakout rooms right now. And I'm going to send a clerk into the room where you are so that we can see if we have all the paperwork. Yes, go to the breakout room, Ms. Coulterman. I just sent you to number 1. And Mr. Baker, I'll send you to 1 as well.
Okay, Judge.
Are you able to get there, Ms. Coulterman? Okay, you're on mute.
It opened up like it was about to open up the break room, but then it brought me back to the courtroom.
All right, so what I'm going to do, I'm going to see, do you see where it pops up for you to go to 2?
Yes, ma'am.
All right, don't go to 2, go to 1. I just sent you back.
Okay, I'm going.
All right, thank you.
Thank you.
And we will see where we are on paperwork. And to the clerks, I just got the paperwork come through.
Thank you, Judge.
And everyone, just give me a moment. All right, we are going to proceed on Savannah Coulterman. Who are the parties?
Michelle Hayden for the state.
Hi.
Hi, Judge. Sorry.
Hi, long time no see.
That angle. Go back. Hold on, this thing's coming back.
Let me see. I've thrown us off a little bit.
I mean, how many members do you have?
Not very many, but she just mentioned it. So.
Yep, Brenda, it is now doing different things for me. We shall see.
There it is.
Yay. You know, I'm always excited over the little things when technology works.
Yeah, for sure.
All right, the court is going to call 2021 CR 7555, State of Texas versus Savannah Dawn Coulterman. Can I have parties announced for the record for the state?
Michelle Hayden for the state.
For the defense?
Eric Baker for Miss Coulterman, Your Honor, who's present via Zoom.
All right, and are you Savannah Coulterman?
Yes, ma'am.
We're proceeding by video because of the pandemic. Any objections from the state?
Nothing from the state.
Any objections from the defense?
No objections, Your Honor.
Ms. Coulterman, I'm going to show you what's entitled Defendant's Consent to Appear by Video Conference. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Next, I'm going to show you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes.
Yes, Your Honor.
Oh, my bad.
No problem. Court will find that the state is in compliance with discovery. Ms. Coulterman, I'm going to show you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
So waived.
State, are you proceeding on the indictment as presented?
Proceeding in count 1 and waiving count 2 and 3.
Any objections?
No objection, Your Honor.
Ms. Coulterman, I'm going to show you a document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am.
Did you understand in count 1, you're charged with aggravated assault with a deadly weapon? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, I understand, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, I understand.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine? Did you understand?
I understand, Your Honor.
Counsel, has your client been able to provide you any defenses to this offense?
She has, Your Honor. Yes.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I believe she does.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, we discussed that issue thoroughly with her, and I believe that, yes, sir.
Ms. Coulterman, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, definitely.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived her right to jury trial. Showing you what's entitled plea bargain page. Did you review that page with your attorney and did you understand it?
Yes, ma'am.
According to the plea bargain agreement, the state is proceeding on count 1 only. Punishment is to be assessed at cap 7 years in the prison. There's a $1,500 fine, affirmative finding of deadly weapon. The state will remain silent on your application for deferred adjudication. The state will take in consideration County Court cause number 655855. There's to be no contact with Leslie, Leslie, Retana, Retana, Julianne Mendoza, Paola, Paola, Mendoza. I believe this MH, is that for a mental health evaluation? You're on mute.
Yes, Your Honor.
All right, there's to be a MIC, MIAF evaluation, TAP evaluation, and gang evaluation. Did you understand that to be the plea bargain agreement, Ms. Coachman?
Yes, Your Honor, I understand.
Defense, is that the plea
Yeah.
bargain agreement?
It is, Judge, yes.
State, is that the plea bargain agreement?
Yes, Your Honor.
Next, I'm going to show you the paragraph entitled waiver of appeal. Did you review that paragraph with your attorney? Did you understand it? And did you electronically sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, I understand, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Then to count 1 in an indictment, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the defendant's plea.
For State's Exhibit 1, its attachments into evidence.
No objection, Judge.
Ms. Coachman, I'm going to show you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, I understand, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. However, the court will defer finding of guilt as you've applied for deferred adjudication. We're going to set this for a PSI sentencing. Ms. Ferguson, how long will it take to have the PSI done? And we'll get a new sentencing date for you, Ms. Coulter.
It'll be on November 9th, Judge.
All right, so we're going to come back on November 9th, Ms. Coachman. What will end up happening is a PSI report. will be performed, which is just a pre-sentence investigation report. So it will give me more information on you. And I will base my decision on your application for deferred adjudication based upon that report I receive and any other evidence that's presented to me. I'm going to ask for a TAP evaluation. And a MIC, my evaluation. Ms. Coachman, do you have any children?
Yes, I do.
What are their ages?
I have one daughter and she's 5 years old.
Okay, where's your daughter now?
She's with my brother that's in the Air Force.
Okay. All right, so we're going to come back on November 9th. I'm going to send you to a breakout room. Probation will tell you what you need to do. It's very important that you make all of those appointments because that's what I'll be, that will be part of what I will be basing my decision upon your application, okay?
Okay.
Your Honor,
that's fine.
Yes.
can I be heard on the date on that? I may have a conflict. I don't know if the court has room on its calendar on the 12th of that week.
Oh, Norma, can we set this for November 12th?
Yes, ma'am.
All right, we can set it for November 12th. And
Thanks,
if there's another issue, just let us know. And
Okay,
Ms. Coachman, the reason why it's set out a month, close to a month later, is because there is a slight backlog, and I want to make sure that the TAP evaluation is completed and the MIC evaluation is completed. So we have the November 12th date, but technically it may not be ready by the 12th, okay?
Okay.
So just put some patience in your pocket. I'm going to send you, Ms. Coulterman, to breakout room number 2.
Okay. Thank you so much, Your Honor.
All right, you're welcome. And Mr. Baker, you can go to breakout room number 2 if you want to. And then I will send probation in there shortly.
Great. And I'll be excused from there, Judge?
Yes.
Thank you, Your Honor.
All right, everyone. I'm going to stop the live stream. Where's Hunter and Meredith, Marcus? I feel like it's that show where you call out everybody's name.
We're here.
All right. So this was our last case for today. So we'll start up tomorrow at 9 a.m. It's shocking for the 187 District Court that we are done. And it's not even 12:30 yet. Brenna, do you want to push through lunch?
Yes, I do.
Okay. She says that because she knows. All right. So I'm going to stop live stream. And then before everyone leaves, we need to go over a couple of